Mr. Speaker, I rise today to speak in support of House Bill 4474, a bill that I was...
Members, a colleague is addressing the body. Please keep order and show decorum. The chair recognizes Representative Elder.
Thank you, sir. A bill that I was happy to co-sponsor. As a young man, I earned a bachelor's degree in history from Wayne State University with a focus on American history. And later, I attended the UCLA School of Law, where all of my non-bar exam courses were focused on constitutional law, including spending a year analyzing the evolution of governmental executive power beginning in the 17th century and culminating in our own U.S. Constitution, where ancient executive power is divided among four recipients: the executive branch, the legislative branch, the judicial branch, and finally the people themselves. We know, based upon William Blackstone's commentaries on the laws of England, which constitutes the preeminent authority on the English common law, as adopted by the American founding generation, that the right to keep and bear arms was understood as a personal right, a right of the individual, a natural right of defense of one's person or home, in short, the right of self-preservation. This common law right traces its origins to the horrific and tumultuous period in England between the Restoration and the so-called Glorious Revolution, when kings disarmed their opponents and declared them in treason against the crown if they continued to bear arms. After the so-called Glorious Revolution, to ensure against an overreaching executive, William and Mary were required to issue the Declaration of Rights of 1689, Article 7 of which codified in the English Bill of Rights and indicated, and I quote, that the subjects which are Protestants may have arms for their defense suitable to their conditions and as allowed by law, close quote. This right has long been understood as the predecessor to our Second Amendment. For my own purposes, I wish it noted, Mr. Speaker, that the English version of this right restricted my Catholic ancestors living under English domination from the right to keep and bear arms. Further, it should be noted that here, our constitutional rights are not limited by class or religion. And in the aftermath of the Civil War, the federal government enacted the Freedmen's Bureau Act in 1866 to ensure that former slaves had the full and equal benefit of laws, including specifically the individual right to keep and bear arms. The United States Supreme Court enunciated this interpretation of the Second Amendment as an individual right in the decision of D.C. versus Heller. There, Supreme Court Justice Antonin Scalia explained that although clearly an individual right to self-defense, the Second Amendment, and I quote, was not unlimited, just as the First Amendment's right of free speech was not. Thus, we do not read the Second Amendment to protect the right of citizens to carry arms for any sort of confrontation, just as we do not read the First Amendment to protect the right of citizens to speak for any purpose, close quote. For example, under the English common law, there was a prohibition on terrorizing people with dangerous or unusual weapons. And this conduct was known as the common law tort of affrighting. Justice Scalia further noted that it was not a violation of the Second Amendment to prohibit the carrying of concealed weapons. Justice Scalia went on, indicating, quote, nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places, such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms, close quote. It is with this basis of historical knowledge and legal precedent that I am happy to support House Bill 4474. Gun ownership is clearly an individual right, and this bill will allow members of the military to exercise their personal freedoms while in service to our state and country. However, just as with the First Amendment, the Second Amendment is subject to reasonable regulation, and House Bill 4474 has reasonable regulations built in. To begin, the expansion is limited to members of the military who have already obtained their CPL licenses or are otherwise in compliance with the law. This is reasonable for two reasons. First, the citizens exercising this right have gone through basic training as part of the military, including training in the use of firearms. These citizens are entrusted with the duty to keep all of us safe when we are in danger. If we can trust them with a rifle to make life and death decisions if need be, then certainly we can trust them with a handgun. Second, citizens upon whom we extend this expanded right have already met the qualifications for holding a CPL. We are not changing the rules in order to reach some new result. Next, this bill is subject to the appropriate command and control of the Adjutant General. I wish to commend the Chair of Military and Veterans Affairs and my fellow colleagues on that committee for a thorough committee process. In committee, we asked several questions, raised several points, and this bill was made stronger as a result. Through that process, we confirmed that if enacted into law, this bill would not limit a future AG's right to restrict concealed weapons carried by civilians. Further, we confirmed that a future AG could limit this right based upon specific reasons under the military chain of command, as long as those reasons did not unduly burden a member's rights, which is a legal term of art that officers are trained to understand and enforce. All told, this is a wonderful example of a good gun bill. There are reasonable regulations of the right being conveyed, and for all the reasons cited, I urge my colleagues to support House Bill 4474 today. Thank you, Mr. Speaker.
Thank you, Representative.